What does international law have to do with PIL? In our previous video, we saw that international laws can either be directly incorporated in the domestic law or they may require further modification of the existing national law. A state may follow either the monist doctrine or the dualist doctrine. In the monist doctrine, international law is higher than local law, and in the dualist doctrine, where there is a conflict of law, local law prevails. There are certain constitutional provisions regarding how international law is incorporated into our domestic legal system. In India, the Constitution endows Parliament with the necessary powers to give effect to international law. However, the executive shares equal power and in practice exercises those powers. However, there is a gap in implementation of treaty law and customary international law. India follows dualism. The Supreme Court has adopted an almost monist approach, though, of incorporation, using its power of judicial review and interpretation to give effect to both treaties ratified by India and customary international law in PIL. This is how we usually begin, and today is no different. A notification dated 17/1/77 was issued by the Karnataka government declaring an extent of 1 acre in timber yard slum by the side of the main road Cottonpet, Bangalore as slum area. Considering the objections, another notification dated 30/12/77 was issued, declaring the entire land as slum clearance area. However, the government issued a notification on January 20th, 1981, cancelling the earlier notification and redeclaring an extent of 14.5 guntas only as slum area. The notification dated 21/81 was challenged by the appellant's slum dwellers, and it was contended that slum dwellers who are affected by the government's action have not been given an opportunity of being heard, and they have been denied equality by denying basic human needs, since a major part of the slum area has been excluded from the operation of the scheme. A single judge of the High Court said that the appellants had no ground to challenge the impugned notification, and even on merits there was no case. They took it up on appeal to the division bench, which agreed with the single judge and just confirmed the judgment. So the Supreme Court, when it finally came up on appeal before them, disagreed with the High Court and held that legitimate expectations among the people living in that area had been raised by the earlier notification. The Supreme Court made it clear that legitimate expectations cannot be denied without giving the people who are going to get affected hearing. Before we examine the remedy and the right to a remedy, which I told you about in the last video, there are some aspects of international law that we will have to familiarize ourselves with. What does it have to do with PIL? How did the Supreme Court integrate international law into our domestic law, even though there is an existing gap in implementation? The answer to this question is what we will be dealing with today. How did the Supreme Court incorporate international law into our domestic law? We have seen how India follows the dualist position. We have already seen that the position in India is that Parliament or the executive have to take action to implement the international law despite signature or ratification by the executive. We also saw in the previous video how in certain cases the Supreme Court has categorically stuck to Indian position of dualism, and I have given the link in the description. However, in certain PIL cases, it vigorously applied international law to the case on hand, regardless of the doctrine of transformation, which we've already done in the previous video. This is another instance of its breaking barriers of jurisdiction, separation of powers, and important legal doctrines and concepts in flexible and proactive ways to increase access to justice. In Entertainment Network India Limited and others versus Super Cassette Industries Limited, 2008, the Supreme Court tried to categorize the various ways in which it has incorporated international law into our domestic legal system. To fill a gap in the law as a tool for interpretation, to justify and fortify its decision, to implement international conventions when they are not in conflict with existing national laws, to fulfill the spirit of the conventions and treaties, to interpret the laws as to reflect international changes, and to honor international treaty ratifications and international law. We will be seeing all this in detail further in this video. In the beginning, the focus was on integrating international law by using it as an interpretative tool or a tool for analysis, since the courts did not want to break the doctrine of transformation. The tone was set by the SC in the Keshavananda Bharati case. This court must interpret language of the Constitution, if not intractable, which is after all a municipal law, in the light of the United Nations Charter and the solemn declaration subscribed to by India. When there are two possible constructions of domestic law, the judiciary gave an interpretation in line with international law. Similarly, when domestic law and international law are contradictory, the courts attempt to give them a harmonious interpretation. Most human rights conventions are based on the key principles of non-discrimination, equality, and state obligation. Therefore, they may be used as a relevant factor in the exercise by judges of a discretion conferred by their judicial powers. For example, the analysis of the type of discrimination would be important in determining the relief. Hence, it would be very important to recognize the nature of discrimination, its causes, the manner in which it is effected, and its impact on the victim in designing a strategy or approach that would lead to a result that would give appropriate relief to the claimant. Similarly, the model of equality in international human rights law is based on equality of opportunity and the obligation of means and results. International human rights law can be used as a tool not only to analyze the nature of the state's obligation in terms of two particular organs of the state, the judiciary and the executive, but also to craft effective mechanisms and remedies for implementation of corrective measures for the disadvantaged through litigation. Aid to interpretation. Madhu Kishwar and others versus State of Bihar and others. The petition under Article 32 of the Constitution challenged certain provisions of the Chota Nagpur Tenancy Act 1908, which provide for the succession to property in the male line on the premise that this is discriminatory against women and therefore ultra vires due to the equality clauses in the Constitution. M.M. Punchi, delivering the majority judgment, turned to Article 21 of the Constitution, which enshrines the right to life to include a right to livelihood, and pointed out that agriculture is not a singular vocation. It is more often than not a joint venture, mainly of the tiller's family members. Some of them had to work hard and the others harder still. Everybody, young or old, male or female, has chores allotted to perform, a share in the burden of toil. Traditionally and historically, the agricultural family is identified by the male head, but on his death, his dependent family females, such as his mother, widow, daughter, daughters-in-law, granddaughter, and others, joined with him, have under the Act to make way to a male relative within and outside of the family of the deceased, entitled thereunder, disconnecting them from the land and their means of livelihood. Their right to livelihood in that instance gets affected, a right constitutionally recognized, a right which the female enjoyed in common with the last male holder of the tenancy. It is in protection of that right to livelihood which the immediate female relatives of the last male tenant have the constitutional remedy to stay on holding the land so long as they remain dependent on it for earning their livelihood, for otherwise it would render them destitute. The court decided that the exclusive right of male succession included in sections 7 and 8 of the Act must be suspended so long as the right of livelihood of the female descendant of the last male holder continued. But Justice K. Ramasamy, in his minority judgment, referred to CEDAW and citing the Human Rights Act 1993 as paving the way for incorporating international treaties to which India is a party or customary international law, used CEDAW as a tool for interpretation and struck down the discriminatory provisions. In Sunil Batra v. Delhi Administration 2, the Supreme Court under Krishna J. has said, in view of the preamble and Article 51 of the Constitution, which obligate the state to respect human dignity and foster respect for the international law and obligations, the courts have a constitutional duty in interpreting provisions of domestic laws to give due regard to international law and countries' international obligations. In Visakha v. State of Rajasthan, also, the court held that the International Convention has not inconsistent with fundamental rights must be read to enlarge the meaning and content thereof. However, as the scope and ambit of PIL grew, several cases challenged this barrier to full realization of the principles of non-discrimination and equality. The Supreme Court felt increasingly restricted in applying its judicial review of state obligations, and the Supreme Court then began to recognize rights and incorporate them into Articles 14 and 21 of the Constitution of India. Francis Coralie Mullin, a British national, was arrested and detained in the Central Jail Tihar under the Coffee-Posa Act, smuggling of foreign exchange. While under detention, she experienced considerable difficulty in having interviews with her lawyer and members of her family. Her daughter was only 5 years old, and her sister, who was looking after the daughter, was permitted to interview her only once a month, and she was not allowed to meet her daughter more often. In Francis Coralie Mullin versus the Administrator Union Territory of Delhi, the court said, it would thus be seen that there is implicit in Article 21 the right to protection against torture or cruel, inhuman, or degrading treatment, which is enunciated in Article 5 of the Universal Declaration of Human Rights and guaranteed by Article 7 of the International Covenant on Civil and Political Rights. The Supreme Court held that the conditions of the detention order, which restricts the interview only to once in a month in case of a detenue, is unreasonable and arbitrary. The court also held that the right of a detainee to consult a legal advisor of his choice for any purpose not necessarily limited to defense in a criminal proceeding, an inalienable part of Article 21 of the Constitution of India. International human rights law sets standards of non-discrimination, equality, and state obligation. Therefore, the models propounded by international human rights law could be used either to challenge existing statutes or rules or regulations or practices which do not meet the standards, to pressure the state to propose or formulate or implement new policies, or to approach the court to direct the state to formulate new policies or undertake administrative measures which reflect and incorporate international standards. To justify and fortify its decision, in the case of Neelavati Behera versus State of Orissa, the court relied upon Article 9(5) of the Covenant on Civil and Political Rights while granting compensation to the victim for the matter of custodial death. International human rights law sets standards of non-discrimination, equality, and state obligation. India follows the dualist position. Yet the Supreme Court, in certain PIL cases, vigorously applied international law to the case on hand, regardless of the doctrine of transformation. Hence, the SC drew from international human rights law in the following PIL cases. As an aid to constitutional or statutory interpretation, either generally or in order to resolve an ambiguity. Example, Madhu Kishwar and others versus State of Bihar, Sunil Batra versus Delhi Administration 2, Vishaka versus State of Rajasthan, and Gramophone Company of India versus Birendra Bahadur Pandey. This was not a PIL. As a relevant factor in the exercise of discretion conferred by legislation and to interpret the law to reflect international changes. Example, Francis Corley Mullin versus Administrator Union Territory of Delhi. As a relevant consideration to be taken into account of the exercise of a discretion by a decision maker and thus subject to judicial review, and as a factor that may be taken into consideration in the development of the common law. Example, Mrs. Valsamma Paul versus Cochin University and others. C. Maslamuni Mudalyar and others versus the idol of Sri Swaminatha Swami Tirukoil and others. This is another instance of its breaking barriers of jurisdiction, separation of powers, and important legal doctrines and concepts in flexible and proactive ways to increase access to justice.